The following is paid programming.
It's time to talk taxes.
New friends, new opportunities, new partners. EG Tax.
It's Ask the Tax Lady with Esther Gulius and EG Tax on News Radio 930 WBEN. To reach Esther now, call 803-0930. Toll free at 1-800-616-9236. And cell calls are free at star 930. And now, live from the WBEN studios, it's Esther Gulius.
Hey, everybody, this is the Tax Lady, and this is our hour to talk taxes. And today, you are so lucky to have our special guest in studio. I had a doctor that called me this morning and said, Esther, I need some advice on my estate. And I said, you got to tune in to our radio show between 3 and 4 on WBEN because our special guest is Jeffrey Katz. He's an attorney that specializes in elder care law, and he's my attorney. I love Jeffrey. And in studio, we have Tiffany Fabian. Hi, Tiff.
Hey there, Esther. Happy Saturday.
Happy Saturday to you and Christopher Fabian.
Hello, Esther.
Okay, so just before we get Jeff on board, so all of you that are thinking about your estate and what happens, how to an elder plan, Medicare, should I do a trust, what is a trust, all that kind of stuff, you have the opportunity to ask a wonderful, intelligent elder care attorney so that you can kind of start to formate your own estate plan. And okay, so
it's very confusing.
Before we talk to Jeff, we have tax school starting, right?
Yep, October 23rd, and either in the classroom or online, and we're taking all safety precautions and doing social distancing and all that important stuff.
And everybody's and shields and all that kind of stuff, right?
Yep, and it meets twice a week, either in the mornings or evenings, or there's that virtual option. So just click egtax.com. The class is completely free. You do have to purchase the book, and for another few weeks, it's only $85. It's a special for early bird. Right. Yep. And so sign up. It's a great opportunity to learn taxes from A to Z. I know one of our supervisors, Dana, she took it as a fluke, and now she's like this all-star who does really well financially. And so it's a great opportunity.
That's true. So if you're somebody that's thinking, gee, I don't know if my unemployment is going to last, I don't know what I'm going to do, we will keep you busy during the snowy season. So go to our website at egtax.com, and you can register right online, right?
Yep. Chris?
Okay.
Definitely.
Chris, anything else happening
Letters.
in your world?
Letters. We got letters. We're getting
stacks and stacks of letters.
Yep,
right?
and unfortunately, we're talking from the IRS and New York State.
Well, now the IRS was sending out letters because they hadn't opened up their mail, and I think that must be true kind of in New York State. So they were sending out letters that were incorrect. Right?
That's right, because they are months behind in the mail. We've had numerous IRS agents tell us they have trailers and trailers and trailers full of mail that they have to go to because they were shut down for 4 months.
And another common letter that I've been getting is identity theft from the IRS, but I've just been discovering that it's really not identity theft. A lot of people, when they were doing the stimulus, they went and filed a zero tax return. And so when they thought they had to go to irs.gov and do that. So when they filed that zero tax return, the IRS thought that they filed. And so when they subsequently went to file again, they are getting a letter that's saying that they're a victim of identity theft when they are, in fact, not.
And so the great thing is you can call EG Tax at 632-7886. And you can bring your letters in, and as a public service to the people of Western New York, EG Tax will help straighten out the mess.
Correct.
Right?
Yep, definitely.
All right. I'm Esther Gulius, the tax lady, 803-0930, 803-0930, star 930 on a cell phone. And our special guest is Jeffrey Katz. He is with Katz and Berry. He's at 8604 Main Street in Williamsville, New York, and his phone number is 633-3363. And Jeff, We thank you for joining us on a Saturday. Thanks for coming in.
Esther, thank you so much for having me. I'm happy to be here, and as always, a pleasure to speak with you and any of our listeners. So.
All right, so this is so great because, people want to know what to do as if you don't die, aging is obvious. So people want to know just what to do to protect their assets, and this is especially, with a change of possible philosophy at the federal level, at the executive level, with taxes that they're talking about raising, things of that nature. This is especially something that people are concerned about. So, first of all, when you see a client, what's the first thing that you try to find out from them, Jeff, to make sure that they even have a need to be concerned?
Well, in the estate planning world, I look at it, there's really three topics that are important to address with every client. The first is, as you said, taxes. Make sure that there's estate is situated so that the taxes would be minimized, both from an estate tax perspective and ultimately an income tax perspective when the kids are inheriting the money. Second is, we talk a lot about elder law, which is protecting the assets if somebody needs to transition from their own home to, say, a nursing home. And then the third is just the basic estate planning, which is to make sure that they have their estate in order so that the assets can be distributed to whom they want, done so in the most efficient manner at the most efficient cost.
Well, let's do the third first. So that would be kind of your will, right?
Exactly. It's really just making sure we have everything in order. So that would be the basics, really are a will, which everybody who has assets and has things that they're concerned about should have a will, which is a directive that someone would write saying, when I die, this is where I want my money to go.
And so, what percentage of the population would you say should have a will?
It's a great question. Anybody who has assets that they are, or family members they're concerned about. So I would say most everybody. Certainly, if you have something that you've accumulated during your lifetime, you own a home, have bank accounts, stocks, bonds, mutual funds, that sort of thing, you should at the very least have a will. And then potentially you should always have the other estate planning documents, which would be a power of attorney and a healthcare proxy.
And so this is kind of uncomfortable because really, when you're talking about these kind of things, it means that your life is at the end. And so do you find that many people come in and kind of afraid because they think, gee, if I do a will, this means I think I'm going to die?
That's a good question, Esther. I think people are reluctant to do estate planning in some situations because they feel it signifies the end. But once they get into the process, and I certainly try and do my best to make it either, I won't say enjoyable, but at least not stressful.
I want to tell you, what's so great about, and Jeff has been my attorney for years, one of the great things is after I get done with Jeff, I think, oh, yay, now I can die. Because, there's a peace in that.
And you know what, I do feel that, Esther, most of the clients, after they're finished, writing a will, doing their estate plan, they actually feel a sense of relief because...
It is, because you want to make sure, the wonderful thing is to know that whatever you're accumulated is going to go in the way you want it to go as best as you can.
And from that perspective, so people who may be nervous to do it, and I can't tell you how many clients I see who say, I've been meaning to do this for years, and then after we're done with the process and sign the documents, they walk out saying, I'm so relieved that I finally got it done.
I'm glad I did it. I know, I'm thrilled. I'll tell you that. I'm Esther Golias, the tax lady from EG Tax. We have special guest Jeffrey Katz. He is an elder care attorney. If you have been wondering what the heck to do with your assets, should you really do a will? Should you have a trust? What'll happen if you pass away? What if you have to go into a nursing home? Now is your chance to get absolutely free advice. And I will tell you, Jeff is the best guy. Many times people who deal with attorneys, they think, oh, gosh. People call me and say, oh, thank you, Esther, for recommending Jeffrey. He's so wonderful. He's really like the best guy in the whole wide world. We're going to take a short break. We're going to be back on the other side with your questions. 8030930, 8030930, star 930 on a cell phone, and our text number is 716-8030930. We'll see you on the other side.
We are family. I got all my
Anna Sigoli is a tax lady from EG
Oh, he did it
Tax,
for you.
And as far as we're concerned, your family, and we certainly want to help you.
And make sure your family is all set when the time comes.
That's right. Well, so Jeff, we have special guest Jeffrey Katz. He's an elder care special attorney, and he's my own guy. I love Jeff. If you have any questions regarding your estate plan, what about Medicaid? Should I give the house to the kids? All that kind of stuff. 8030930, 8030930, star 930 on your cell phone. And let's go to Fred, who's been waiting for so long. Hey, Fred, how can we help you?
Hey, Esther. I'm thinking of taking my Social Security a year early. I'm 65. I'm on Medicare. I make a small part-time salary. I have a state pension. My wife, on the other hand, works full-time. She makes just north of $100,000. Am I going to get whacked with the penalties and that for making too much money on our income tax?
Well, it's not a penalty. It's just that 85% of your Social Security is going to be taxable.
Okay.
I mean, and that's going to happen next year and the year after, as long as you're making that kind of money. So it's not a penalty, but 85% of your Social Security is going to be taxable. So what you really need to do is sit down, and I would suggest you give us a jingle. We'll figure it out, what the tax liability is, because when you wait, you're going to have an 8% increase when you finally start collecting your Social Security. So it all comes down to a mathematical equation.
Yeah, because
So-
we'll run the numbers to tell you how many years
Right.
you would have to wait to recover that if you
And-
decide to wait. Or short.
Well, it's really not a loss,
Not a
but
loss.
it's 85% taxable, which is going to be next year. Once half of your Social Security added to your other income exceeds 32.5, it becomes taxable, and
I meant
until
the
you get to
loss in the
85%.
increase of his Social Security if he waits a year.
Yeah.
Yeah.
So call us 632-7886. We'll plug all the numbers in. We'll tell you what you'd get from your Social Security, what the taxes would be, and then you can make a decision for yourself.
But I know if I were you, just looking at it quickly, I would take the Social Security. Usually, take the money, right, Esther? Usually.
Well, usually that is true, but when that 85% is factored in, it becomes less of a windfall.
And another thing
And
he
then he can put money into an IRA too, so you can take that money from your Social Security, put it in an IRA, be completely tax-free, and then you have the income. I mean, there's a lot of angles that you could look at.
Okay, I'll give you.
Okay, Fred? Hey, thank you for calling.
Bye.
Yeah, Chris, you were saying.
I was going to say another thing he has to look at, especially with his wife's salary, and he said he was already on Medicare, is IRMA. The Medicare increase, because if he's on a New York State pension with her making that kind of money, adding the Social Security into it, he may be looking extra for the Medicare side of things as well.
Right, so now he's got the 85% plus IRMA,
Yep.
right?
Yep.
But again, if he puts the whole $7,000 in an IRA, that eliminates a lot.
Yeah,
of
and even load up the wife's 401k, 403b, whatever it may be.
So those are kind of things that we can help you with,
Yes.
Fred. Okay, and then we had a text.
Yep. The text says, is the president's $300 FEMA unemployment going to be depleted due to Hurricane Laura?
I mean, they're printing money. They're printing money that they don't have. So I'm certainly not the head of the Treasury, but they're printing money. So I think they're going to be able to do it. So, and remember, the federal government prints the money and the Fed buys the debt.
And-
So it's kind of a game of, it's kind of a shill game. So I don't think you have to worry. If they say they're going to pay you, they're going to pay you. Whether it's going to be depleted money because of the federal budget deficit, God only can tell, right?
Right, and that still has to pass the House and the Senate.
Right. They're working it out right now.
Yeah, they're still trying to figure out the Postal Service.
Okay, let us talk to Mr. Jeff. Jeff, so gifting. Is gifting a technique that people should use in their estate plan?
There's really two types of gifting, Esther. Gifting, of course, being that, let's use the word parents giving money away to their children. And
Right.
the two reasons people gift money from an estate planning perspective, one is for tax purposes to try and minimize or decrease what might be their taxable estate. Through the years, that's been a big part of the planning process. Currently, the estate tax exemptions are very high. The federal estate tax exemption is over $11 million. The New York estate tax exemption is well over $5 million. So if an estate is less than that, there won't be any estate taxes at the time of death. So gifting from that perspective doesn't really have a benefit. It would just be a gift to your children, not taxable to mom and dad, not taxable to the kids upon receiving it. The other gifting that we really do a lot with in terms of planning is gifting away assets to try and get them out of the parents' names in case they needed long-term care. Kind of, we call it elder law planning. You're trying to position it so that mom and dad might be able to have Medicaid pay for the nursing home care, and that's where gifting is done most commonly these days.
Now, is there a maximum gifting amount that you can gift to your heirs? I know there's the 5-year look back, but I mean, and so obviously before you think that you need to go into a nursing home, that would be when you do the plan, right?
Right. You mentioned the 5-year look back. What that would be is that if money is gifted or transferred from mom and dad to the kids, there would be it has to be done 5 years in advance if we're ever going to deal with Medicaid and trying to get mom or dad to have Medicaid pay for the long-term care. In terms of answering the question, is there a maximum what can be gifted? Basically, not really, because the gift and estate tax is unified, and as a unified tax, they could gift up to the exemption amount, which those numbers that were very high. So.
15,000 is the maximum
per year, but they
year.
can give up to that 11 million for the
Exactly.
federal,
Right.
5 million
Right.
for the state.
Yeah,
you're
many
saying
people
that-
think about the 15,000. The 15,000 is a number that could be gifted away without having to file a gift tax return and not having to have any implications on the gift tax. But that's irrelevant to the Medicaid planning because that really starts at $1 and has nothing to do with either the estate or gift tax exclusion. So.
Okay, so you're saying if, I don't mean to put words in your mouth, but let's say that a couple is looking at the possibility of going into a nursing home and they only, let's say, have $100,000. So husband and wife could gift $30,000 per child, right? Husband 15, wife 15, which is 30. And if they have 4 kids, they could really gift away the entire kit and caboodle in 1 year and then start the clock ticking before a nursing home, right?
The clock ticking. Let's kind of talk about that because this comes up all the time in my office. Basically, what that means is if somebody goes into a nursing home, it's going to get paid for unless they have insurance coverage, which most people don't. But if you happen to have long-term care insurance, that might pay the bill, and Medicare or regular health insurance will pay a small amount for rehab. But after that's depleted, then it's going to be either Medicaid or private pay. And if you have money, then if the person in the nursing home has money, it's going to be private pay. If they don't have money and reach the Medicaid limits, which we should talk about, but if they reach the Medicaid limits, then Medicaid will pay the bill. But if the money was gifted away, so using your example that we were just talking about, Esther, if somebody has gifted away $100,000 or $120,000, then they would be ineligible for Medicaid for a period of 5 years. So that's where the 5-year looks back, regardless of what the amount that was gifted away. If that gift occurred in a 5-year period, then that money is includable in their assets when they go to apply for to determine whether or not Medicaid would pay the bill.
Okay, go on, Chris.
So, speaking of the 5 years, so say mom and dad give that money away. Now it's 4 years and 5 months into it. or 9 months into it, so there's still 3 months left. They would only have to pay for that 3 months before
Private pay.
private.
They would only use that, the private pay for 3 months, exactly. So basically what happens when someone is applying for Medicaid, there's a look or even an audit of the 5 years of finances. So anything past 5 years in a day, doesn't matter how much was gifted away. It's only that 5-year period.
Right. So that's why it's so important that somebody, as they age, if they have assets and they want to preserve them, that they would make that plan. I mean, I think planning is so important in everything, but especially as you age, because you want to make sure that if you want to make sure that your assets go to your heirs, it's important to talk to somebody like you, Jeff.
It's a big part of the estate planning attorney's world these days. Certainly, what I've been doing now on a regular basis for unfortunately decades is helping
Have you
client.
done your estate plan, Jeff?
Not yet. No.
Hopefully, many years away, but using the same concept. Yes, I have three wonderful children. I want to make sure that we take care of along with my wife Susie. But in the planning perspective, it's absolutely you're so correct, Esther. The most important thing to do is sit down with a qualified professional, make sure that the goals are being accomplished, and if necessary, try and protect the assets if that's what the person wants.
Now, let's say that you got 3 kids, but you don't especially trust them. Can you gift a trust as opposed to the kids?
When we talk about gifting away the money can be gifted one of two ways. It just has to be gifted outside of out of the name of mom and dad, and if it's gifted away, it has to be done so in advance.
All right, so a trust would work.
A trust could work.
Okay. I'm Esther Gulius, the tax lady from EG Tax, 8030930, 8030930, star 930 on your cell phone. We're going to take a short break, and we'll be back with our special guest, Jeffrey Katz. He's an elder care attorney. Get your questions in line. We'll see you on the other side.
We are family.
Hey, I'm Esther Gulius, the tax lady from EG Tax. We are dealing with estate planning, Medicare, Medicaid. If you're somebody that's alive and you want to make sure you pass on your assets to your children as best as you can, our special guest is Jeffrey Katz from Katz and Berry. They are elder care specialists, and we're so thankful that Jeff is here. We're going to go to the phones. We've had Leonard hanging from Lancaster. Hi, Len. How can we help you?
Well, I got a question for Jeff. Little quick background. My dad is 90 years old at the present time. About a year ago, he had a stroke. He was on Long Island. We went down to the island to square things up and bring him back up here. An attorney down there said he could cancel his will because he wanted to change it. So she said instead of changing it, just cancel it, and everything, she used the word insight to it. I really don't understand what that means. Can you help me out there?
Yeah, I'm not sure why the advice was given to cancel the will, because if he had a will that he liked and had a distribution pattern that he was comfortable with, then that should still be his will. There's really no, at least I can think about, quickly, an advantage to canceling it. If you don't have a will, basically, just kind of answer it a different way. If you don't have a will, New York has written a will for everybody, or distribution pattern for everybody, which is called intestacy. And if somebody dies without a will, the assets are passed by intestacy. And I guess if you were to cancel your will or revoke it, then it reverts back to intestacy. So, Leonard, would there have been a reason? Was there something in the will that your dad that didn't make sense from your dad's perspective?
Oh, well, due to financial situations over the years, stock market up and down, he had to reduce the amount of gifts that he was going to give to cousins, et cetera, et cetera. Some people maybe wanted to take out altogether, and everything would go as a result of my brother and myself.
Okay. Well, then basically, when they say cancel the will, revoke the will, revoke the distributions to people besides your brother and yourself, and that. So in that situation, it may have made sense, or certainly I would always think if he has the capacity then to write a new will to you and your brother. But if there is no will, and you are the only surviving children, and there's no surviving spouse, then the money would go to you through intestacy.
Well, that explains it. I just didn't want to get stuck with, oh, gee, I should have had one, and now it's too late, I appreciate it, Jeff. Thank you.
No problem.
Hey, Jeff, so let me ask a question. So then would that have to go through probate?
It would. Either
So
way.
then there's a big cost for that, right?
Yeah, what probate is the process of actually using a will or intestacy in order to have an executor and administrator appointed. So whether or not there's a will or intestacy, it does have to go through what people call the probate process, and the cost is actually relative to how much work there needs to be done and that sort of thing. And it is something that can be avoided in some situations, certainly with a lot of assets. If you have a beneficiary designation or a revocable living trust could avoid probate. So there are ways to avoid probate if that is the goal.
Okay. So so thank you very much for that. All right, we have a text tip from
We do. It says, if our residents now in Florida for 25 years, but we have an old will from New York State, is it still valid, Jeff?
The law is if you have a will and it's valid in the state where it is written, so in other words, if you write a will in the state of New York, you move to Florida, that will is still valid and can be utilized in Florida. And vice versa, and we've certainly had that. Somebody writes a will in the state of Florida and retires up here in sunny Buffalo, then that will could be valid here in the state of New York. So,
Okay, so as long as it's valid in your state, you're good to go,
correct.
right? But really, to make sure, wouldn't they really want to have a second look, don't you think?
Absolutely. If somebody moves from one state to another, they should meet with an estate planning attorney in that new state just to make sure whether or not the will needs to be changed, whether there are some state law requirements, and certainly other ancillary documents such as the power of attorney and the healthcare proxy should be reviewed to make sure they comply with state law also.
Okay, all right. That's it's not that expensive anyway. So it's when something so important as when you're gone that you would want what you wanted to happen. I would think that you might want to have that second look. Okay, let's go to line 1. It's Nancy.
Hey, Nancy, how can we help you?
Hi, thanks. I would like to know the advantages or disadvantages of leaving a home in my will to one of my heirs or adding the name to the deed right now while I'm alive as a co-owner.
Okay, so when you say co-owner implies what's called joint tenancy, meaning, so if you think of a bank account, two people have a bank account with two names on it, that would be joint tenancy, and that goes automatically to the other person. Similarly, that could be done with real estate. You could add your daughter's name to your house as a co-owner, and then the advantage is if you were to pass away, then she would have the house the next day. She could live in it, she could sell it, and it would not require what we were just talking about, the probate process for that house to move into her name. That would be the co-ownership. And then if I could expand my answer for your question a little bit, another way to do that is you could put her name on the deed and you could keep what's called a life estate. Life estate is really life ownership. Mm-hmm. So you'd both kind of own the home, and there might be an advantage to that in terms of trying to protect the house if you did need long-term care and nursing home care. So,
And of course, the other thing is the tax benefit, right, Jeff?
And you certainly could have, the tax benefit would be, there's two types of taxes in that situation. One would be the property taxes. We want to make sure that Nancy, you would maintain your property tax exemptions. If you have any exemptions, such as a senior exemption or a veteran's exemption. So no matter what, we want to make sure that's maintained. Mm-hmm. That's always very important when somebody's adding someone's name to the deed, that we make sure we get that done the right way.
Okay.
And the property tax and the income tax, right? Because in a life estate, then when the daughter inherits the house, she's going to get a stepped-up basis. But if she adds the daughter's name to the deed prior to her death, then the daughter doesn't get the stepped-up basis except on half. So from an income tax standpoint.
And Esther, that's why we call you the tax lady. So exactly right.
But I mean, so I'm thinking, because many times, it seems to me that, and I have seen it in my own work here as a tax expert, is that many times we think our kids want the house, but upon our death, they really don't want the house and they sell the house. And so with you putting the name on the title prior to death, then your daughter's going to end up getting your basis in the house rather than the stepped up basis, at least on 50% of it, and which would make her pay more taxes.
Okay.
Okay?
Thank you.
All right, thank you. I'm Esther Golias, the tax lady from EG Tax. 8030930, 8030930, star 930. We have Jeffrey Katz, an elder care attorney. He's just so smart. I love Jeff so much. He's at 8604 Main Street in Williamsville, New York. His phone number is 633-3363. And we have line 4, we have Joe. Hey, Joe.
Hello.
Hi, how can we help you?
Well, I have a question for Mr. Katz.
Yes.
I think I have a complicated issue here. My wife and I set up an estate plan, comprehensive estate plan, and it's a living trust, but it's irrevocable. It's not a revocable trust, an irrevocable trust. And I wanted to refinance my current home because of the lower rates, but I'm being told I cannot do that because this is an irrevocable trust.
Okay, so your question, let me answer it in two parts. The short part would be, can you refinance your home or mortgage your home if it's inside of an irrevocable trust? And the answer to that is it's up to the bank. So obviously the bank that you've applied to is telling you no. In my experience, most banks say no to that. But that's kind of a bank decision as to whether or not they'll allow a home that's in an irrevocable trust to be refinanced or remortgaged in any way, shape, or form. But Joe, what your question kind of gets at in the broader picture would be, should you have an irrevocable trust? And obviously at the time that it was set up, there was a determination by yourself and the attorney helping you that it made sense and it had advantages. So your real question now would be, the pros and cons of keeping the irrevocable trust in place and the advantages you have there versus taking it out, putting in your own individual name and refinancing the house. So your question is correct. It is a complicated question and one that probably can't be answered in the next 15 seconds.
He should give you a call, but
Darn.
with the irrevocable trust, if it is him and his wife as the principal parties, can't they agree to cancel the trust, then refinance, and then put everything back in the trust again, do another trust
Yes. So yeah, Chris, the answer to that is certainly an option. It could be done. But again, that's got the pros and cons, because if you do
the
that,
5 years,
we're starting the 5-year clock again, and so forth. So
yeah.
That's where this is. And you started by saying, Joe, it's a complex question. It is, but so I think you need to sit down either, with myself or the attorney who helped you originally and figure out the pros and cons before you make a decision. So
I would like to sit down with you. I'll call your office for an appointment. And
well, I will tell you if you do, you'll be glad you did.
Thank you, Esther.
All right, that's the truth. That's the truth. Everybody loves Jeff. I'm Esther Golias, the tax lady from EG Tax, and again, Jeff's phone number is 633-3363. He's located in Williamsville at 8604 Main Street. I'm Esther Golias, the tax lady. If you need, and let's face it, we're all dealing with mortality, and we're dealing with all kinds of complex financial decisions. And if you want any of your questions answered, if you kind of want to wade in the water, you can give us a call, 8030930, 8030930, star 930 on a cell phone. And we have a text here, Tiff.
Yes, ma'am. The text says, I have a revocable living trust. After means my wife passes away and my kids keep the trust open and draw money as needed, or must they distribute and close the trust? I have a revocable living trust after my wife passes away.
After me and my wife pass away.
Okay, I was reading the text board. And my kids keep the trust open. Can they draw money as needed, or must they distribute it and close the trust?
Okay, so that question is really dealing with the terms of the revocable living trust. So in the trust itself, it will say what should happen to the trust, and whether or not it should be kept open or not is up to the terms of the original trust as it relates to those terms. So it's impossible to answer here really quick, because the revocable trust can become irrevocable at the time of death and can continue on for many years thereafter as another trust or as a multi-generational trust. So it depends on.
You got to go back to the original paperwork and see how it's set up.
See what it says. See what the goals of the person are.
So really, you're dictating from your grave, kind of thing.
Well, yeah, absolutely, Esther. Many families want to set up trusts. A common example for a trust would be if people have young children and they want, and they have minor children who can't receive assets if they were to tragically pass away. If that was to occur, then there would need to be some kind of a plan, a trust that would be put in place to make sure that the assets for the young children were put in trust and managed appropriately. So that would certainly be the kind of trust, whether it's a revocable living trust or a will can have that trust contained in it. That's very common as an ongoing trust. So.
Okay, I'm Esther Gulias, the tax lady. 8030930, 8030930, star 930 on your cell phone. You can text us at 716-8030930. We're going to take a short break. We'll be back with Jeff Katz on the other side.
We are family.
Hey, to us, your family. I'm Esther Gulias, the tax lady. We're joined in studio with our special guest, Jeffrey Katz. He's an elder care specialist, an attorney. I'm going to tell you, if you haven't seen Jeff, I mean, you're just missing out. And so we're so thankful that he's here. All right, Tiff, you want to go back to our next?
Sure. Thanks for such an informative show. I'm a 70-year-old female. I own my own home, no other assets. If I end up in a nursing home, will they force me to sell the home to pay for my care? I haven't left it to anybody, but I want to leave it to my niece. The will is not written yet. Also, our life insurance proceeds safe from nursing home demanding payment.
Okay, so there's really two questions there. One is, basically, if you go to a nursing home, can they force you to sell your house? The short answer is no. You can keep the house, but the value of the home could be, can't force you to sell it, but they could put a lien, they being Medicaid, could put a lien against the house if they are paying for your care and the house has not been, as we talked about, gifted away with a life estate and protected. The other part was life insurance proceeds. Life insurance, if there's a cash value to a life insurance policy, that cash value counts as assets. And so if a life insurance policy has a $10,000 cash value, it's no different than having $10,000 in the bank account.
Okay, so, but
Get a
if you're
will.
a single person, you'd be entitled to $14,000, right?
That's correct. So the Medicaid limitations are, in order to qualify for Medicaid in Erie County now, if you are a single individual and you have no spouse, then Medicaid will pay the bill when you get down to the exempt amount. The current exempt amount is just slightly higher than $15,000. And if you're a married couple, there's a community spouse living at home, the community spouse is allowed to keep the house regardless of value, and we'll call it approximately $100,000 in assets.
And could she do a life estate to the niece?
She absolutely could do a life
So
estate.
that might be the thing to protect the house, is just do a life estate instead of.
Correct. So the question, to answer the question, the best way to do it again is to plan in advance, do a life estate with your niece, and that would protect the house for you.
All right, and then let's go to Patty.
Hey, Patty.
Hi, I have a question. Are you familiar with the long-term care through Robert Wood Johnson Foundation?
I am. So that'd be the partnership program, correct?
Yes. It was partnership with New York State.
Yes.
And after you pay the first 90 days, you go on Medicaid without looking at your assets. Now, are you familiar with that?
I certainly am, yes.
Oh, okay. And I just have a question regarding that. once you pass, does Medicaid try to get your assets after that?
Okay, no. How's that for a good answer for you? No. The advantage of having a long-term care insurance policy, which is part of the partnership program, is that it does allow the family to keep the assets. So if you bought that type of insurance policy, that was a good decision, and you should be happy about it for yourself. And it will allow, if you do need to use the policy, it'll allow assets to be protected for your family. So good job.
Yes. Well, what I've done, you do have to provide any income you receive during that period of time.
That's correct. So, but if you have the policy, my quick advice to you is don't get rid of it. Keep it. You made a very good decision, and you have a good policy, and having it as part of the partnership program makes it even more valuable. So, good job.
Thank you.
All right, great.
That's all
Hey,
I wondered.
Thank you for calling. We're going to go to, I'm trying to move everybody
Well,
along
go to
with
Mike.
all these calls. Let's go to
Hey, Mike.
Hey, Mike.
How you doing?
Good.
I think I've met Jeff at one of your symposiums at
Yeah.
your office.
Yeah.
But I got a question, and I can't remember. I do have a will. I'm 69. Got two houses. My ex-wife, we've been divorced 40 years. We get along real good now. I do want to leave the house to one of my sons with her having lifetime,
Occupancy.
Tenancy.
And, tenancy. And actually, what's the difference between a revocable trust and a non-revocable trust? And do they both start at that 5-year tick down for Medicare if you go to a nursing home?
Okay, so there was actually a lot in your question there, but I'll answer the short part is a revocable or revocable and an irrevocable trust. The difference is, as it sounds, one you can revoke and amend, and the other you cannot. The revocable trust, a basic revocable or what's called a living trust sometimes, that trust does not protect the assets if what we're trying to do is protect them from for a Medicaid qualification perspective for nursing home care. So revocable versus irrevocable, there's big differences. Again, depends on your personal situation and what you're trying to accomplish. In your situation, it would depend on, again, what you're trying to accomplish, and it's probably too tricky for us to figure out here. You'd need to sit down with somebody
You
to
need more
make the
than 5
determination.
minutes, Jeff?
Yeah.
Okay, and let's go to John. Hey, John.
Oh, John dropped.
was
We
John.
got Tracy on the phone.
Hey, Tracy.
Hi, I'll try to make this quick.
Yeah.
About 11 years ago, my father did a life estate to my two brothers and myself. And I guess it's a good problem. He's doing really, really well, but in light of the pandemic, he's going to move in with one of my brothers more for just the mental stimulation. So we're going to sell the house, but we've got this life estate, and we're trying to determine the best way to do this.
Okay, I guess.
So he's going to move out of his house? Is that?
If he's going to move out and you want to sell the house, is that the question?
Yes, because he's by himself, and with the pandemic, he can't get out like he used to. So we want to move him into where he's with family now. So we're going to sell the house, but it's a life estate. He's still living.
Okay, so houses that have been transferred with a life estate can be sold. That is a short answer to your question. So I would always start if somebody's asking me for advice on that question, what I always say is do what's best for the family. That's what's most important. If it's better for him to live there, forget the economics for a second. You got to get the person safe and sound where they need to live, and then the house could be sold, and then the proceeds get divided up based on the people's interest in the house. In terms of who's got the life estate and who else is on the deed.
But the unfortunate thing is
basis.
it'll become taxable.
There certainly could be a tax consequence on the sale. If a house that's been transferred with a deed with a life estate is sold, there may be a tax consequence to
the kids.
to the kids, to the remainderment. So that again would be part of the consideration.
Now but of course, if he took it out of the life estate and sold it himself, it would be a tax-free sale.
He could
But
always
then, But then the
right.
unfortunate thing is he'd have the cash if he goes into a nursing home.
Correct. There's no perfect solution to the scenario as it's presented there. And again, it's we might have conflicting interests between the economics of the situation and the living situation, and the family's got to determine to do what's best for the people involved.
Right. And then, Tracy, if you want to know the tax implications for you and your brothers, give us a call on Monday, and we'll work everything up and tell you what you need to do.
Yeah, that question is asked often to us, so give us a buzz at 632-7886.
Yeah, and of course, if Dad never goes into a nursing home, it doesn't make any difference. You just sell it tax-free, and away you go, right?
Yep.
Okay, and then we had one last text, Tiff.
Yeah, and we have another caller holding. It says, follow-up text, Jeff, my wife passed away in 2007, had no will. Who would have to tell me to go to probate? So when my dad passes, he has no will. How does probate contact me?
Okay, so basically, and it's a common kind of confusion in terms of how probate works. What really happens is if your dad was to pass away in this situation and he had an asset, let's call it a bank account. He had a bank account that you as his heir needed to get control of and have transferred to yourself, then you would need to take affirmative action in order to, which would be utilizing the services of going to the probate court. You would need to take affirmative action in terms of getting that bank account into your own name. That's where probate would be required. And there's different limitations. Current limitation, it was actually changed just recently in New York State. The threshold for what's called full probate is now $50,000. It used to be $20,000, so it's gone up quite significantly in New York State, which makes the process much easier if there's less than $50,000 in that one asset that we're dealing with. So again, that would require you probably to hire an attorney, or definitely to hire an attorney to get you through that process.
All right, and then our last caller, Tiff.
Hey, Tom, how can we help you?
Yes, I was listening to that executive order with not paying the Social Security and your pay stuff. Does that have to be paid back?
Okay, so if it goes into effect, then no, it would be just completely canceled. So it won't, but again, it's up in the air. We don't know what's really going to happen with that. So that would not go into Social Security and wouldn't have to pay it back.
Okay, because they were telling me that, or telling if was hearing that it did.
No, I mean, if it's suspended, they should not ask for it back. But again, nobody knows right now because it's kind of in a
holding
limbo,
pattern,
so to speak.
Yep.
So anyway, but thank you for calling, and thank you everybody for listening. I'm Esther Golias, the tax lady. We want to thank Jeff Katz. He's an elder care specialist, absolutely great attorney. He's on Main Street in Williamsville, 8604. His phone number is 633-3363, 633-3363. It's Jeffrey Katz, Katz. Thank you, Jeff, for joining us. Tiffany, Christopher, until next week, I'm Esther Golias,
Thank you.
the tax lady. Talk to you later.